All right, so we're going to do this little article. Hunter Biden's legal woes keep getting worse. All right, so this is via the Epic Times by Catherine Yang. I'm using Zero Hedge's version because it's a little cleaner. All right. A judge ruled that Hunter Biden will need to be arraigned in person, denying his request this week to attend hearing virtually. Special counsel David Weiss has argued that Hunter Biden should be required to make in-person court appearances, opposing Mr. Biden's request. Hunter Biden does not contend he is injured or indigent. Mr. Weiss wrote in response to Mr. Biden's request. Mr. Biden has been indicted in federal court on felony gun charges, including 2 counts that he allegedly made false and deceptive statements when he purchased a gun and submitted a statement that he wasn't an unlawful user of drugs, and 1 count related to his possession of a gun while addicted to drugs. Interestingly, not one for disposing of the gun illegally in a dumpster next to a grade school, but hey. An in-person hearing is more important to promote the public's confidence that the defendant is being treated consistently with other defendants, Mr. White wrote. Hours later, the court sided with Mr. Weiss, denying Mr. Biden's request to attend through video conference. United States Magistrate Judge Christopher Burke wrote that he understood Mr. Biden's arguments that the hearing would likely be short and travel and logistics are a burden, but the event was significant. Although initial appearances in criminal matters are often short in duration, our court has always considered them to be important, he wrote. The hearing is one of the few occasions in a criminal case where a defendant physically appears in our court before a judge in a setting that helps emphasize the integrity and solemnity of the federal criminal proceeding, which, again, just imagine the audacity of Hunter Biden. You know what? It's just a short proceeding. I don't need to go. Seriously, dude. The hearing is one of... Judge Burke pointed out that the matters to be discussed in the arraignment were not discussed in Mr. Biden's previous arraignment in July, during which his plea bargain fell apart. He is expecting to address Mr. Biden's pretrial release conditions as well. Mr. Biden's arraignment is scheduled for October 3rd at 10 a.m. Not seeking special treatment. On Tuesday, Mr. Biden had filed a motion to appear in court by video conference. His attorney, Abby David Lowell, had argued that his client is not seeking any special treatment in making this request. He argued that making his client travel across the country for what should be a rather short proceeding would put a financial burden on the government, which provides Mr. Hunter with Secret Service protection, and put logistical burden on a downtown Wilmington, Delaware, where the court is. Gee, how considerate of them. They care about the taxpayer. No matter whether in person or virtual, he will waive reading of the indictment, which is merely a few pages and could easily be read at a video conference, he wrote, adding that Mr. Biden would be entering a plea of not guilty. There is no reason why he cannot utter those 2 words by video conference, because, of course, he's so much more important and doesn't need to deign to travel to Delaware to have to face these charges in person. He's pleading not guilty. Unforeseen issues. Mr. Weiss argued in his response that outside of the pandemic, the federal court in Delaware has almost always held in-person hearings for initial appearances and arraignments, and that Mr. Biden should not be treated differently. He noted that the 2 cases cited in Mr. Biden's argument had allowed for virtual appearances because the defendant was wounded and could not travel. If convenience was a legitimate basis to warrant virtual proceedings, every defendant would ask for them in every case, Mr. Weiss wrote. He argued that much could be lost with a virtual hearing, such as the opportunity for the judge to accurately assess the physical, emotional, and mental condition of the defendant, a factor that may weigh on pretrial decisions, such as release from detention. Oh, let's be honest here. There's no chance that Hunter Biden will be remanded. He noted that the previous arraignment with Mr. Biden already resulted in anything but routine outcome, and that an in-person arraignment should occur again this time in case the court needs to address any unforeseen issues that arise. Like the last time when their sweetheart deal fell apart because it was illegal. On July 26, Mr. Biden appeared in federal court in Delaware, reportedly ready to plead guilty to 2 tax misdemeanor charges in a deal that would allow him to avoid a felony gun charge. During the hearing, the plea bargain appeared to fall apart when the judge asked additional questions about the rationale for details of the agreement. The defendant and his previous attorneys were prepared to answer the court's questions. Mr. White were not prepared to answer the court's question, Mr. Weiss wrote in his new response. Defendant provided contradictory testimony, and his previous attorney apologized to the court for the way the defendant and his counsel chose to answer the court's questions. The confusion they caused resulted in the courts twice recessing the proceedings, only to ultimately defer a decision. Mr. Biden's previous attorney, Christopher Clark, had stepped down from his case with the reason that he may need to appear as a witness in Mr. Biden's trial should the plea bargain itself be part of the case. Later, 3 more attorneys on the team stepped down without citing a reason, and Mr. Lowell remaining as lead counsel. Mr. Weiss wrote in his letter that he will be asking the court to order certain conditions for the pretrial release of Mr. Biden, and thus he should be present. Given the serious felony gun charge at issue in this case, the court should have the opportunity to assess the defendant in a live setting when discharging recommendations for conditions of release. Mr. Lowell said on Good Morning America that he believes the charges against Mr. Biden will be dismissed before trial. First, as to the political pressure, I want to make sure that everyone understands that after 5 years of investigation, that the prosecutors knew all the facts, and the only charge as to when the investigation and the only change as to when they investigated and today is that the law changed. But the law didn't change in favor of prosecution. The law changed against it, Mr. Lowell said. A couple of federal courts have found this gun charge unconstitutional. Really? I mean, that's new. House Oversight Committee Chairman James Cormer has alleged that the political pressure is why the charges weren't brought earlier, having heard from the IRS whistleblowers who allege the Biden administration slow-walked the investigation against Mr. Biden. Mr. Lowell maintains that the government entered into a plea bargain with his client, which meant that the charges should not have been brought, while Mr. Weiss argues the plea bargain did not take effect. Mr. Lowell is arguing that the gun form in question is unconstitutional, has already successfully been challenged, and that on the facts, he has a successful defense. I mean, I'd like to see the case. I actually somewhat agree with that, but the law is the law, and Hunter Biden most definitely violated the law. And, the big thing is that he's getting away with all the tax stuff. He's going to end up getting away with they allowed the statute of limitations to lapse on a lot of this more serious stuff. So he's still getting a slap on the wrist regardless. But this is funny that he's so narcissistic that he actually thinks that he should not have to go down to court to address these in person. That's how entitled they are. That's how, no one messes with a Biden. That's the quote. It's a little bit more gruff than that.